Hello, this is Chuck Stoll continuing our antitrust section looking at price fixing. Like monopolization cases that we heard about earlier, price fixing has long been a matter of concern in antitrust law. But for the most part, price fixing cases are not judged by the rule of reason. They are held to a stricter standard. Price fixing is prohibited by Section 1 of the Sherman Act. It prohibits restraint of trade, including price fixing. Now, price fixing between competitors has been broadly prohibited, and this goes back to the very early days. There are many price fixing cases or restraint of trade cases. We will just touch on a few major ones, but they're much more common than the Section 2 monopolization cases that we heard about in our earlier presentation. So let me start with the Addyston Pipe and Steel. This is a case that reached the Supreme Court in 1898, so a very early case. The Sherman Act, if you'll remember, was passed in 1890. So this was a naked restraint where the agreement's sole reason was to eliminate competition, to enhance prices, and it was found illegal. Essentially, this is the Supreme Court putting its stamp of approval on the Sherman Act. The next important case at the Supreme Court was the Trenton Potteries case, where the decision was made in 1927. So this was a trade association for sink and toilet manufacturers who tried to argue for reasonableness, that they weren't exploiting consumers in an unreasonable way. The Supreme Court decided against them, and they said the end result of every price-fixing agreement, if effective, is the elimination of one form of competition. Essentially, what the court is saying here is that even reasonable price fixing is prohibited. Or to continue from their decision, agreements are held to be in themselves unreasonable or unlawful constraints. And this was reinforced in a case that came in to the Supreme Court, decided by the Supreme Court in 1940, the Socony-Vacuum gasoline case. So Socony is Standard Oil Company of New York. It merged with Vacuum. It later became known as Mobil, and then later merged into ExxonMobil that we know today. The oil majors at that time were disturbed that the independent gasoline retailers were selling gasoline very cheaply. We were just coming out of the Great Depression, and the majors agreed to purchase oil or gasoline from the smaller companies that were known as dancing partners in order to maintain prices. To some extent, this was a continuation of some of the New Deal policies that were designed during the Great Depression to try and push prices up in a period of deflation. In any case, the Supreme Court decided against Socony-Vacuum, found them guilty of price fixing, and were not interested to hear that this was designed to make the market more steady, or was a continuation of an earlier policy that had been dropped by the government. The Supreme Court reinforced that price fixing agreements are unlawful per se. So per se means by the existence. So a per se violation is a bright line rule. It is always prohibited. So defendants cannot argue reasonableness or efficiency, the kinds of things that would be looked at under a rule of reason standard. And so that means that sometimes cases that might have social benefit are also going to be prohibited, right, under any kind of per se rule. But a per se rule makes it substantially less costly to enforce. Essentially, we just need to look to see, was there an agreement or an attempt to an agreement? And under a per se rule, if firms agree to fix prices, it is illegal. And that saves a lot of court costs. We don't need to look at all the pros and cons. That may take many years. Here, all we have to do is see, was there any kind of agreement? Essentially, the reason per se is used for price fixing cases is that these kinds of conspiracies don't usually have an efficiency impact, whereas the large companies could be efficient as well as being dominant. In recent years, there have been some cases where defendants tried to argue that their actions had a pro-competitive effect, and the lower court considered that using a rule of reason standard, and that then went to, on appeal, it was overturned and said no, price fixing is still per se illegal. Now, restraint of trade can take a variety of forms. So direct price fixing, where competitors agree to charge a particular price or a particular discount. It can be bid rigging, where the companies set prices in a sealed bid or open bid auction. Bid rotation, where the winners are determined ahead of time, or market division, where one company says, I will only sell to these customers if you sell, and I'll leave those other customers to you. These are all per se illegal, and these have been very widely interpreted. Let me look at a couple of cases that affected college and university admissions. In 1993, there was a case known as the Ivy League overlap case. And the Ivy League was sharing information on individual applicants, individual students, in determining financial aid, and they agreed that they would all make the same offer to the same students, so that students would choose their school not based on cost, but based on other reasons. This was seen as a restraint of trade, and they were challenged on that behavior. Now, the 8 Ivy League colleges signed a consent decree. Again, that's a negotiated settlement. So that was Brown, Columbia, Cornell, Dartmouth, Harvard, Princeton, Penn, and Yale. But MIT, who also was participating in the overlap group, decided they would take it to court. They lost in court, and it was found to be restraint of trade. Both sides appealed it, and after the appeal, the MIT also agreed to settle. There is a much more recent college admissions antitrust case that just was brought in 2019, and so we haven't seen the impact of it. But the National Association for College Admission Counseling has a code of conduct, and it's one that some of you may be familiar with, that students had a May 1st deadline for admissions, and colleges would respect that and not recruit students who had already committed to another college. Colleges were also not supposed to actively recruit transfer students. They could accept transfer applications, but they weren't supposed to advertise and promote their school to students who were already enrolled at another school. And colleges were not supposed to offer financial incentives or special benefits to encourage students to make an early decision. So this was seen as a restraint of trade, and the colleges did consider, or the admissions group did consider, should they fight it in court, but they decided that it was going to be too expensive, and so they decided it was cheaper to sign a consent decree, and they dropped those elements of the code of conduct that were seen as anti-competitive. And so that means there may be some changes, at least in some places, for individual school admissions. Turning more broadly to businesses, we find that price fixing cases are common. So while the Section 2 monopolization cases are very unusual, the Section 1 cases happen every year. Individual presidential administrations will typically bring hundreds of criminal cases and collect billions in fines and sentence people to prison for violation of the Section 1 of the Sherman Act. And that was true under the Obama administration and continues to be true under the Trump administration. In the most recent report, they reported 30 prison sentences for price fixing. Many of those were related to real estate foreclosure auctions, over $1 billion in fines, continuing trials for bid rigging, for price fixing. Canned tuna was found guilty of price fixing from some of the major companies, perhaps food that you have in yourselves. And the Department of Justice has been investigating no-poach agreements between employers where they won't hire employees from another company. And again, that's being questioned as a restraint of trade or a anti-competitive action. The reason that price fixing cases are so common is even though most of these are clearly illegal, the profitability of setting your price up above a competitive level is in many cases irresistible for the companies who would like to take those high shared monopoly profits. This has been Chuck Stull from Kalamazoo College talking about Section 1 cases, price fixing and restraint of trade.